Good morning. I'm Ward Farnsworth, the Dean of the University of Texas School of Law. And
Nice.
well, that's very kind. I say that for the benefit of visitors to our community for the sake of this conference, to whom we are especially grateful. Many of you have traveled some distance to come participate in this wonderful event, and we thank you very much for that. So I'm delighted to welcome all of you to our conference 40 years after Gregg v. Georgia, a national conference on the death penalty. This conference examines the death penalty in the United States at a very appropriate moment. It's being held at the right time. It's a time when the practice is facing increasing scrutiny, and we're seeing a national debate about its future. There's talk of reconsideration of it in the Supreme Court before long. The conference is also being held at the right place. I'm proud to say the University of Texas School of Law has been a leader in preparing lawyers to engage in capital punishment litigation and in rigorously studying the practice of capital punishment. Our capital punishment clinic was established almost 30 years ago, and some of the panelists participating in this conference, Dana Lynn Reeser and Walter Long, were students in our clinic more than 2 decades ago before going on to their own very impressive and important careers in the field. Our Capital Punishment Center, which enriches the practical training of our students with academic and other professional activities, was established a decade ago and has held important conferences on death penalty topics in each of the 10 years of its existence. The work of the clinic and the center is a vital part of the law school, and I want to thank and congratulate its faculty, Raoul Schoenman, Jim Marcus, and Jordan Steiker, and the center's current fellow, Molly Spaulding, for their relentless energy and commitment. This particular conference is especially important as it includes an unusually wide range of influential actors in the American death penalty. I dare say it's a dean's dream. I can't imagine a roster of better people to come address this topic than we've been fortunate enough to assemble for today and tomorrow. I'd like to personally welcome and thank especially the judges who are here today, including those from our own jurisdiction. We have Judge Elsa Alcala from the Texas Court of Criminal Appeals, Judge Keith Ellison from the U.S. District Court for the Southern District of Texas, Judge Patrick Higginbotham, Senior Judge on the U.S. Court of Appeals for the Fifth Circuit. And I'm also especially pleased to welcome Judge Alex Kaczynski from the United States Court of Appeals for the Ninth Circuit, who's also serving this week as a jurist in residence here at the law school. I had the pleasure of working for Judge Kaczynski during law school, and we welcome him to our law school very warmly. I would also like to extend a welcome to Mark White, the former governor of Texas. And it would take too long to extend personal welcomes to all of the other distinguished participants here in this room, other judges, executive officials, prosecutors, defense attorneys, legislators, and distinguished professors. I hope it's enough to say that I'm delighted, we're all delighted, that you've accepted our invitation to come discuss your important work and your distinctive perspectives at this event. Finally, I know events like this, and I think we all know, they don't just happen. They require a great deal of work on the part of many faculty and staff, so I want to mention a couple of them. I want to single out first Eden Harrington, our wonderful associate dean, whose work as the director of the William Wayne Justice Center involves her in the careful planning of all events such as these. And Rachel Sidopoulos, who assists her in those efforts and has worked tirelessly on this event, especially those of you who traveled have probably worked with Rachel. And when you think about all the things that could go wrong that aren't going wrong, you can thank her. Rachel. Finally, Rachel Galloway is our events director here at the law school, and she also has done an enormous amount of detailed work to make this a great couple of days. Angel Leffingwell also has been indispensable in getting this conference planned and running. So I want to thank all of our staff for making this a great conference. Okay. Finally, I'm very pleased and honored to introduce to you the current president of the American Bar Association, Paulette Brown, to make some welcoming remarks of her own.
Thank you. Thank you, Dean Farnsworth. Good morning, everyone.
Good morning.
Oh, nice. Good morning. Thank you. I am real pleased to be here, especially at UT. You've already thanked everyone, but I'll thank you for allowing this program to happen on this campus, and to commend you for all the work that you do at your Capital Punishment Center. when we talk about anniversaries, usually it's a good thing. In this case, it's not so much. It marks the 40th year, so I'll just say that we're marking the 40th year of the Gregg versus Georgia decision, which if you didn't know what it was, you wouldn't be in the room. But looking at it now, 4 decades later, it's really essential for us to examine where we are as a nation on this extremely critical issue, and bringing together, as was mentioned earlier, a very diverse group of individuals, including judges and prosecutors and public defenders, academics, government officials, journalists, victims advocates, and a whole host of people to carefully study this issue and which direction we are going and what it is that we can do and how we can educate ourselves further about this very critical issue and how we can proceed in the future on this very complex topic. And so I won't go through the people who are esteemed who will be speaking here today because it's already been done, but I would like to thank, because I am the ABA president after all, so I have to give publicity to our own entities, and that is the American Bar Association's Death Penalty Due Process Review Project and its chair, Seth Miller, and the Death Penalty Representation Project, the ABA Commission on Disabilities, the ABA Criminal Justice Section, and the ABA Section of Civil Rights and Social Justice. All of these sections really helped and did a great job in making this event a reality and the success that I know it will be. Of the many important topics that will be discussed over the course of this conference, I wanted to share some of my own thoughts about the impact race has on the death penalty and the effects of implicit bias in the system. I'd also like to share with all of you a bit of American Bar Association's long history of studying and advocating for improvement for capital punishment system in this country since the Gregg decision. As you all know, since the reinstatement of the death penalty in America in 1976, more than 150 people have been released from death row with evidence of their innocence. 13 of those cases have been right here in Texas. No matter how you feel about the merits of the evils of capital punishment, this is deeply troubling. It attacks the very core of common law. As Sir William Blackstone wrote, "It is better that 10 guilty persons escape than 1 innocent suffer." Nor can the racial disparity in the administration of the death penalty be overlooked. Of the more than 2,900 inmates currently on death row in this country, you probably already know these statistics, 56% are of color, although they only account for 37% of the population. And since 1976, and I'm giving you another statistic I know you already know, 34.5% of the 1,431 defendants put to death in America have been black, even though they made up only 13% of the population. A study of interracial murders found that a black defendant murdering a white victim was far more likely to get the death penalty than a white perpetrator who murdered a black victim. Numerous states have done studies on this topic, and they all point to a racial disparity in the system. Jurors in Washington state are 3 times more likely to recommend a death sentence for a black defendant than for a white defendant in a similar case. Louisiana Law Review research shows that odds in the state of a death sentence were 97% higher for those whose victim was white than for those whose victim was black. And then we have, as a part, the ABA has done a number of assessments, and we've also examined whether race influences outcomes of capital cases in 4 states. And after accounting for aggregating factors, found consistently that whites were more likely to be sentenced to death than those that kill blacks. And then there are some specific statistics for Ohio, Tennessee, Georgia, and Indiana. Indiana in particular, 94% of the people who were executed since 1972 had white victims, whereas only 64% of homicide victims in the state are white. The reasons for these stark disparities cannot be pinned on one factor alone. However, researchers by a team of law professors of psychologists in 2013 found a prominent factor for this racial disparity is implicit bias. And so a study was done of 445 jury-eligible people in death penalty states, and found that they maintained racial stereotypes, and use race in judging the value of a life. The study also found that so-called death-qualified jurors held stronger racial biases than potential jurors who would be excluded from serving in death penalty cases. So, you know, since we know, everybody familiar with implicit bias? I know you are, yes? How many have taken the implicit association test? Wow, very good. So I would recommend that even though we are all the do-gooders in this room, that we are all really interested in this and we don't have any racial animus, not one bone in our body, that we all take this test, because the news is, everybody, that all of us, none of us, not a single one of us, me included, is exempt from having implicit bias. And so in order to understand it, and so that our decision, even all of us who want to do the right thing, who are well-intended, all of us need to understand what our own implicit biases are before we can matter, before we can effectuate any change in the system, and before we can help others to do and eliminate any other implicit biases that they may have. So, you know, everyone, as I mentioned before, it's not, you know, sometimes people say it's just judges and prosecutors. No, they're not the only ones who have biases. And a lot of times stress is what causes these biases. And so when you have tremendous caseloads, whether you are a public defender or prosecutor, the thing is to keep it moving. And so when we're under this stress, that is when our implicit bias surface the most, because we don't have time to put our unconscious feelings in check. And so we are trying to help this process. We are, through the Diversity and Inclusion 360 Commission, which I created as a part of one of my initiatives, we are creating training materials. We wish we could do it for everyone, but we know that our commission is only a one-year commission, and we are trying to create training materials for judges, prosecutors, and public defenders. And so we have videos. The one for judges is already complete, and by the August, videos for prosecutors and public defenders will be complete, explaining how implicit bias has an effect on decision-making and in all that we do. In the judges video, we have 3 actual judges who are giving testimony as to and acknowledging the fact that they have implicit biases, and unfortunately how they may have impacted their decision. And a perfect example is how we are all affected by implicit bias. There's an African-American judge on the video who talks about the fact that he sentenced a white defendant, and the white defendant wrote him from prison and said that he discriminated against him because he was white. And he said that hurt him to his core for anybody to accuse him of discrimination. And so it caused him to go back and look at his record. And he said he was devastated to find that his sentences were harsher for African Americans than they were for anybody else. So, you know, it's very powerful. It's a very powerful lesson to explain to everyone how we really need to understand this and the role that it plays, and the role that jurors have in this whole process, and whether there should be some instructions, some preliminary instructions when jurors are first seated as to implicit bias and the effect that it can have on their decision making. And so we're also preparing some written materials to go along with this, so that people will have something to refer to on an ongoing basis. And I've asked the company if they could prepare an app for the ABA and for everybody to use so that they can have refreshers. But, you know, over the past 40 years, the American Bar Association has really been in the forefront of death penalty issues and death penalty cases. We've filed numerous amicus briefs, and we've had many and numerous volunteers from large firms and other firms to work on some of these death penalty cases on a pro bono basis. Our House of Delegates have passed numerous resolutions. We don't have any resolutions actually reflecting on the merits of the death penalty, but we want to make sure that it is administered in a fair manner. And we believe that the execution of individuals who are under the age of 18, for example, is not fair. We believe that people who have certain disabilities or various level of abilities, that should be examined as well. And so we have really a lot of things to think about. And we have to, you know, when everybody in the 90s, they developed this tough on crime theme that, you know, unfortunately, we as lawyers, we sort of sat back and we kind of let it happen. We were not as proactive as we should have been, and I'm among the guilty. And so at that time, death row, the population of death row inmates grew to extreme and extraordinary levels. And so we have to try and tamp back and look at what it is that we're doing. We have to come up with some solutions so that the death penalty will not be overused in a manner in which it has been. We have to explore solutions to find out what is missing, why it is that so many innocent people, why we discover later on after people have served many years on death row that they have not committed crimes. This is what I hope and anticipate that this conference will bring about some solutions to these really critical issues concerning the death penalty, what it is that each one of us can do in our own communities, in our law firms, in our respective organizations, how we have to take a closer look and examine each situation on its face, not taking into account anything that we may know about a particular group of people and assume that what we know about this group of people applies to each individual case. So I will let you know that the American Bar Association stands ready with its more than 400,000 members to assist in any way that we can. I know that viable solutions will come from this conference, and I look forward to receiving them and wish you a wonderful conference. Thank you very much.
Thank you very much, Paulette. My name is Jordan Steiker. I'm a faculty member here at the University of Texas School of Law. On behalf of my colleagues in the Capital Punishment Center, Ralph Schoeneman, Jim Marcus, and Molly Spalding, I'd like to welcome you to our annual Capital Punishment Center conference, 40 years after Gregg. This year's conference is special because of our partnership with the ABA's Death Penalty Due Process Review Project. It's also special because of its ambition in reflecting on 40 years of the modern American death penalty. As virtually everyone in this room knows, in 1972 in Furman versus Georgia, the United States Supreme Court invalidated prevailing capital statutes as violative of the Eighth Amendment. Backlash to that decision led to swift passage of 35 new capital statutes. In 1976, in Gregg versus Georgia and its accompanying cases, the Supreme Court upheld death sentences obtained under 3 of the new capital statutes passed post-Furman, inaugurating the modern era of the American death penalty. Over the ensuing decades, we've seen dramatic changes in state death penalty statutes, changes in federal constitutional regulation of the death penalty, and changes in capital practices on the ground, including new approaches to capital defense, prosecutorial decision-making, and executive clemency. Now, 40 years later, it seems proper to assess the successes and failures of the modern American death penalty. At retrospective events such as this, it's common to hear the phrase, "What's past is prologue." One of the reasons for its frequent invocation is the fact that the phrase has several divergent meanings. At its most basic level, what's past is prologue suggests that past events have shaped and informed present practices, a point that is unquestionably true. A slightly stronger version indicates that we've reached a crossroads, that past events have produced a decisive moment, such that we should understand those events as mere preliminaries to an impending main event. And the strongest version of the phrase is a sort of determinism, that past events not only produced a looming decision, a looming decisive moment, but also dictate an inescapable or unavoidable outcome. Because I am not an 11th grade English student, I will not burden you with my own views about which of these usages is most faithful to its appearance in Shakespeare's The Tempest, when, fittingly for this conference, Antonio employs "what's past is prologue" to suggest the murder of Alonzo. But I will say for these purposes, for our purposes, the first two senses of the phrase are particularly apt. It's quite impossible to make sense of the present moment of the American death penalty without attending to the ways in which the past 40 years have influenced its current shape. In addition, we do seem to be at an important crossroads. Many observers believe that the death penalty faces the prospect of imminent abolition, fueled in part by Justice Breyer's and Justice Ginsburg's recent call for the court to revisit the constitutionality of the death penalty under the Eighth Amendment. I am less confident that we can predict a short-term outcome or that the past has foreordained a particular result. Predictions about the direction of the American death penalty have been notoriously and spectacularly wrong. In the early 1960s, few people expected that executions would cease in 1967 or that prevailing capital statutes would be invalidated in 1972. And after Furman was decided, few people believed the death penalty would not only survive but thrive, returning in a more robust form in a few short years. With these thoughts, I welcome you to our conference. I look forward to days of discussion about how death penalty law and practices have been transformed over the past 40 years and about the significance of these transformations. I'm grateful that so many of you have taken the time to participate in this conversation, and I'm thrilled to have the range and quality of speakers and moderators assembled here today. I'd also like to thank Misty Thomas of the Death Penalty Due Process Review Project for her extraordinary efforts in making this conference possible. And to our partners, Seth Miller and Ginny Sloan, in planning this event. I'd also like to thank Dean Farnsworth and Eden Harrington for their longtime support of the Capital Punishment Center and for their enthusiastic embrace of this particular event. And I joined Dean Farnsworth in thanking the many folks at the law school, including Rachel Sidopoulos, Angel Leffingwell, and Rachel Galloway, for working so energetically to make the conference run smoothly. And now I'm going to turn the program over to Misty.
Thank you. Good morning, everyone. I am Misty Thomas. I'm the director of the ABA's Death Penalty Due Process Review Project, and most of this time I will probably be the taskmaster on time and pushing everyone to keep moving, but I will just now compound the delay with a few of my own remarks. But it is an honor to share the stage with these two wonderful people and the dean, as well as the many distinguished speakers you're going to hear from. And as Ms. Brown said, the ABA doesn't take a position on the death penalty per se, but rather our project works to uphold the promise of the Fifth Amendment, or part of that promise, that no person shall be deprived of life without due process of law. So our project, in addition to doing major assessment research, we also try to provide technical assistance to policymakers and stakeholders who want to maybe implement some of the ABA best practices that we have on myriad issues related to capital punishment. We also really try to listen to all of you, those of you who are on the front lines of the death penalty work in all of the various capacities, so that we can help be nimble and able to thoughtfully develop initiatives and fill gaps where the field needs additional work or additional research. So in conjunction with our colleagues at the ABA, many of whom are the generous co-sponsors of this conference, we try to do more than just that research, but we study and recommend new policy recommendations for the ABA so that we continue to lead and have the ABA be a voice for reform. We help with amicus briefs in significant capital cases. We currently also house 2 new initiatives that try to tackle things that no one else in the nation is working on right now, one of which is our Serious Mental Illness Initiative. The other is our Capital Clemency Resource Initiative. And I won't detail those now because if you come to the Pecha Kucha or lightning talks later this weekend, you'll get to learn a little more about both of their work. There's also information on tables in the rear of the auditorium that have resources and materials so you can learn about our work or come talk to us about it. I do hope that we'll be able to sustain those projects in the coming years, as we are the only organization in the country working on them, but as you know, we have to find resources and support to be able to keep doing those things. And Jordan spoke a bit about sort of the origin of why we're here, but I do want to briefly recall the moment a couple of years ago when I started this job, when I first realized that 2016 was going to mark the 40th anniversary of the modern death penalty. And I did feel strongly that it was going to be an important time to stop and reflect both on that history and where we are today. And I realized that I couldn't think of any other gatherings that weren't focused on a particular role in the system. There are trainings for defenders, prosecutors, even judicial trainings. There may be gatherings for folks working on abolition or other reform. There might be, academic symposium, but there are not many fora where all of the folks in those different groups might come together and share their perspectives collectively or brainstorm and learn from one another. So I thought that that would be an exciting opportunity. And at that moment, I was also prompted to reread Gregg, the decision itself, and I was struck by the confidence that that decision placed in largely just trial phase procedures to ensure that it felt like there was a capital punishment scheme that, quote, seemed to satisfy the concerns of Furman. And the court focused very specifically on those features of Georgia's reconstituted statute that were the bifurcation of the trial and sentencing, the weighing of the statutory aggravators and mitigators, the charging of lesser included offenses, and just one appellate procedure that the state Supreme Court would review for proportionality and arbitrariness. And I noticed that so few of those areas that Gregg talked about are actually resolved elements of our law, and I thought just in the last year we've continued to have challenges like Hall v. Florida on how aggravators are determined, whether judicial override is appropriate, whether jury unanimity is necessary, challenges based on data like Ms. Brown cited on racial bias are ongoing, and others that implicate these post-Furman improvements to the structure. So those are not resolved, I realized, and then I was also struck by how many things in Gregg that are being hotly debated, the things that are being hotly debated now weren't and couldn't have been contemplated in Gregg. They didn't discuss things like the implications of EDPA, lethal injection challenges, or the problems for states getting access to lethal injection drugs, the advent of DNA exonerations, and our society's evolving understanding of juvenile brains, intellectually disabled individuals' mental illness, and the impacts of unqualified and underfunded counsel being compounded. So while a conference at the 40th year, or not an anniversary, but 40 years out, should talk directly about what Gregg said, it also must talk about all the things that Gregg wasn't able to say, and I think we're going to get to do that here. And so with all of that, when that was swirling in my head, I was really thrilled when my wonderful steering committee agreed that they wanted to tackle a conference like this, and then even more thrilled when UT agreed and wanted to co-sponsor it, because we are honored to be part of this law school's long tradition of excellent academic conferences on the death penalty and the rigor and excellent scholars that are here. It's just really great to be part of this. In closing, I'd like to quickly thank our wonderful co-sponsors who helped make this come together. I know you've heard some thanks, but the section of Civil Rights and Social Justice at the ABA is our home. They founded our project and continue to be partners in our work. We also work frequently and collaborate with our friends at the Criminal Justice Section of the Death Penalty Representation Project and the Commission on Disability Rights, all of whom have representatives here. I'd also like to thank my chair, Seth Miller, and my immediate past chair, Jenny Sloan, because they truly have been instrumental in the work of this project. And then a quick couple of administrative things, and we'll get started. First, feel free to find me, Jordan, or anyone with, they have a staff label if you have questions as we go throughout. We're happy to help you. In the bag that you got, there's a sheet with maps on it that hopefully can guide you around the campus, and including there's a note for a jury room. So if you need a quiet place to go during any point in this conference to have a private conversation, make a quick phone call, send an email, there's a space constantly available for us to do that and step away. You just kind of wind around. So check your map. That same sheet has Wi-Fi access information if you need to get online. But I know none of you are going to be reading email while our brilliant presenters are on stage, because you wouldn't do that. You can see from the program we do have a busy agenda. We're going to try to stay on schedule. We also have substantive sessions over both lunches. So at that time, I'll come back up and we'll invite you to sort of move out of the room, grab a lunch if you ordered one, and come back in so that we can hear those wonderful conversations. But we will try to infuse some breaks through the day. There's some 15-minute breaks you can walk around, run to the restroom. But just check your agenda or listen if I pop up so you know to come back. You won't miss any of the action. And finally, we'd like to invite all of you to join us tonight in the Jamil Pavilion, which is also on your map, for a cocktail reception so you can catch up with old friends, make some new friends, talk about some of the wild theories you heard in the last day or so, and we'll also have occasion to enjoy each other's company tomorrow night over dinner and drinks and remarks by Steve Bright. So thank you all for joining us. I'm thrilled that you're here. Welcome to the conference. We're going to start right away with our first panel. Thank you.